Justice Paul Dery, whose contempt application against Anas Barima Anas and 4 others was dismissed as frivolous, has petitioned the Judicial Council over the ruling. His lawyers say the case was originally scheduled to be heard on the 12th October, and it came as a shock to learn that it was actually heard and dismissed today, September 29. Also, the High Court has dismissed a case brought by 14 Circuit Court judges and magistrates to stop disciplinary proceedings against them, arguing that the proceedings initiated by the Judicial Council as a result of Anas's bribery allegations were in breach of the Constitution. So, what is the way forward in the investigations against the judges and magistrates indicted in the judiciary bribery expose by Anas Barima Anas? This is today's big story with me, Stephen N.T. Now, Justice Dery's contempt application, which sought imprisonment for Anas and the others on grounds that they had disrespected the court and sought to scandalize it, was dismissed by an Accra High Court as frivolous. That happened today, September 29. But Justice Dery is unhappy with the decision, as he claims it was wrong for Justice Gertrude Tokonu, who sat as an additional High Court judge, to hear and dismiss the case today when, in fact, it was originally scheduled to be heard on the 12th of October. There are other dimensions of Justice Dery's argument which makes interesting reading. Let me go through that briefly, and then we will continue, get onto the line and do some discussions. Now, it goes by saying that petition from Justice Paul Dery, and it reads, "Please accept our compliments. We act as solicitors for and on behalf of Justice Paul Uta Dery. We wish to bring to your attention certain happenings in the above-mentioned matter that is of grave importance to the administration of justice and of the violation of the rights of our client due to fair hearing of his case filed in the Accra High Court. Our client caused a contempt application to be filed against Anas, the acting editor-in-chief of the New Crusading Guide, Samuel Frimpong, editor of the New Crusading Guide, Ernest Addo, deputy editor, the New Crusading Guide, Nathan Kwabena Anochi Adesi, Chief Executive Officer of Star FM, also known as Bola Ray, Suleiman Barima Media Foundation for West Africa, which was scheduled by the Registrar of the Fast Track High Court to be heard on the 12th of October, and they have attached that notice. Now, to our surprise, the petition continues. To our surprise, we heard on the news, on Joy FM and on City FM News, that the said contempt application has been heard today, 29th of September 2015, and dismissed by the Honorable Justice Gertrude Tokonu, sitting as an additional High Court judge. This comes as an absolute shock to us, since on the motion paper, the said case is scheduled to be heard on the 12th of October. Furthermore, we are reliably informed by the bailiff responsible for the service of the application on respondents 1, 2, 3, 4 that the matter has not been served, and also that none of the respondents has till date filed an affidavit in opposition to our application. Our client has also not been served with any hearing notice seeking to change the date endorsed on the said motion paper. This, in our opinion, is a clear violation of our client's right to be heard in court. Our client instructs us to petition your good office to cause an investigation to be conducted into the matters raised above, and to ascertain their veracity for the necessary remedial action to be taken. We wish to state that this letter is without prejudice to our client's right to appeal against the said ruling. So that's the full petition. And let's get onto the telephone lines now and speak to lawyer Yao Opong, who is a lawyer who will be joining us. But right now we have in the studio Kwachi Afre Nuyama, who has been following these developments very closely. Afre, how are you, sir?
Great, Stephen.
Today you've been very busy. Now, tell me, this petition, did you? I mean, I know you have been covering both the dismissal of the 14 and dismissal of this contempt case. Did that come to you as a surprise?
Exactly, because when the High Court had the contempt application today, one point that the judge made, and there was a major point, a major reason why, the basis on which Justice Gertrude Tokono dismissed the entire application, that the lawyers for Justice Dery, the applicant plaintiff in this particular matter, failed to appear in court at all. So you would assume that based on that, of course, they brought this matter in court, they were aware, but simply refused to appear in court, perhaps because they thought they were no longer interested in the matter. So subsequently, with this coming from lawyers for Justice Dery, it's pretty surprising that, and if there's anything to go by, that could perhaps explain their absence in court today, because the case, from what they are saying, was scheduled for somewhere in October, 12th of October.
Yeah. And so, I mean, my key reason was that, I mean, as somebody who was covering the case and you went to court, you have observed all the arguments, and you've rightly stated that their inability to appear in court was cited as the main grounds for which the case was more like thrown out. So I'm just basing my question on the fact that knowing now what we know through this petition, that they actually were not served, did it come to you as a surprise? Just the fact that they claim now that they were not served, they were not aware of any notice to reschedule the hearing from October 12th to today.
Well, two sides here. The judge gave, based on how events unfolded in court today, I can say the judge gave a side of the story, and it was clear that to her, and the case was expected to be heard today. And they are saying something different. But of course, they've provided some sort of evidence, court documents, proving to that extent, that from the documents that the court registrar gave them. And of course, this is the judge who is handling all the cases concerning the Anas Aremeyao Anas investigation, the petitions and all that. So the judge was expected to be in the known, if from my interaction with lawyers for Justice Dery. So it's pretty surprising that if indeed the court was aware, the court would then go ahead to hear the matter. And one instructive point that they raise, which makes this more curious, is that the first, the second, third, and fourth respondents in this matter have not been served at all.
Yeah.
And also that none of the respondents have till date filed an affidavit that's evidence in opposition to the application. So it would have been expected, and again, if what they are claiming is anything to go by, that this particular process would have been followed. But they've petitioned the Chief Justice now, and the key point they are making is that due process was not followed, and what they say is, quote unquote, there was a clear violation of their client's rights. It will be pretty interesting to see
how this goes. But who was in court today? I mean, reading from here that they have information from the bailiff responsible for the service of application on the first, second, third, and fourth respondents in the matter, and that they had not been served. So if they were not served notice for rescheduling, were they in court today?
They were not in court, Stephen. In fact, in court today was only the representative, the executive director of the Media Foundation for West Africa, Suleimana Barima, who was
but he's cited in the contempt, so it means that he was served. It means that he had received notice for the rescheduling and appeared in court, but otherwise the rest didn't turn up.
The rest didn't turn up.
Right. So this is interesting. Now, were you able to speak to any of the legal representatives from this side? They didn't turn up at all.
They didn't turn up at all. But one point that Mr. Dery's lawyers are making, which I find pretty interesting as well, is, and as I was talking about earlier, that even whilst the case was scheduled for today, they had absolutely no idea. They heard about it first, in fact, on the Joy Midday News.
I see.
And also they heard it on CTFM. So that, pushed them to file this push for this particular case in court. But in citing the reasons for this ruling, the judge throwing out the contempt case, Gertrude Tokono, beyond the fact of the absence of the lawyers for these Justice Dery in court, she also mentioned the fact that ordinarily she would throw out such a case because it's incompetent and lacks merit. She also mentions that, and I'm sure you remember, Steve, that last week lawyers for Justice Dery had withdrawn an injunction application against Tiger IPI, restraining them from going ahead with the premiere. And according to the court, it would be wrong for the judge to punish anyone for dealing with this particular matter when, again, that same issue had been withdrawn from the court.
Right, Afraid, let me get on to the telephone lines and speak to lawyer Yao Opong, who is joining me now. Good evening, sir.
Yes, good evening.
Great. Now, I know that some would argue that this is just an administrative problem. I mean, the issue about rescheduling the hearing from October 12 to today. So tell me, if a case is scheduled to be heard on a particular date and perhaps hearing is changed, what are the processes that must be followed to ensure that each party to the case is duly notified?
Well, thank you very much, and best regards to your listeners. First of all, the question is, the fundamental question before I come to yours, is whether or not, when a case is fixed for hearing for a particular date, that date can be changed, can be extended or abridged. Now, our rules make it clear, without sounding technical, but under 80 of our rules, Rule 4, really deals with instances where the court may extend time for hearing of a matter or abridge the time for the hearing of the matter. And when you look at, in the case of abridgment, which relates to what we are discussing now, that the court may, on such terms as it thinks just, by order extend or reduce the period within which a person is required or authorized by these rules or by any judgment, order or direction to do any act in any course or matter. So the court has that power, but in practice, at least, as far as I know, it is usually an application by one of the parties that, in view of some urgency or the nature of the case, the court may abridge the time so that the case can be heard expeditiously, in order that the urgency or the nature of the case can be tied into the abridgment. So, but in most cases, or in all cases, I understand it, the other party must be served with that application. Then the court will then agree or grant it or dismiss it.
Right.
But when done, of course, the parties must be notified, because the fundamental principle is that in the context of adjudication in a court of law, there must be fair hearing, and fair hearing also implies fair opportunity to be heard.
In court.
Fair opportunity to be heard also implies adequate or reasonable time given to all parties to be heard.
So it means that, judging from the explanation you have offered us, it means that Justice Dery and his lawyers indeed have a case.
Well, from what I heard, the application for contempt had been adjourned to 12th October, if my memory serves me right.
That's right.
Now, and so by practice, I, the lawyer, would be expecting to go to the court, probably with my client or his representative, or I alone, go there on the 12th. I do not know under what circumstance the abridgment was done and whether they were the other party, especially the party who has brought the application, must be the one that should even have the notice of the abridgment. In any case, I am yet to know, and I stand corrected, an instance where a court so much by itself has abridged the time for hearing of an application to the extent that the one who filed the application may not have been given a reasonable or adequate time to come to court to move the application. Without touching on this specific matter, I think that generally speaking, reasonable time, adequate time is important, because the dates that are given, they are deemed to be a date given by the court or the court registry. Usually lawyers would suggest a date, but there is, in practice, the registrar cannot even go beyond a certain date.
Right.
So when the application is filed, the other party thinks that the date given is not suitable or is too long, you may bring the application for abridgment, but it has to be served or notified to the other party.
Right. So without sounding prejudicial, I need to ask you, will it matter really if, for example, the Judicial Council finds out that the judge, the sitting judge, Gertrude Tokonu, erred in the ruling? In that case, what effect will that have on the ruling? Could it be set aside?
Well, my view on this point is this. I am not able to say that the letter or the petition to the Judicial Secretary is the appropriate procedure, because what happened in court today is a judicial function that has been exercised. And I stand corrected, but I'm yet to be convinced that an administrative function can be used to set aside or make an adverse finding in respect of the performance of an administrative function.
So what would have been what would have been the right procedure to address this if you see this as a judicial function?
Okay, I will tell you what I would have done without prejudice to what they have done. I would have rather appealed against the case, or probably filed judicial review in the nature of the certiorari at the Supreme Court to quash the decision. That is, if indeed my client were dissatisfied with the procedure that was adopted to strike out the application. But I would not have, and I'm not saying that what they've done is wrong, I wouldn't have resorted to an administrative act and expect that it should legally or properly in law adversely affect the performance of the function and a judicial function in a court of competent jurisdiction.
Right. Mr. Yawapong, we're grateful for your time on today's big story. Thanks very much. Let's move on to other issues. An Accra High Court dismissed a case brought by 14 Circuit Court judges and magistrates to stop the disciplinary proceedings against them. The lower court judges argue that those proceedings initiated by the Judicial Council against them in relation to the bribery expose by Anas were actually in breach of the Constitution. However, in dismissing the case, the Court of Appeal judge, Justice Gertrude Tokonu, again, who sat as an additional High Court judge, said the court could not constitute a guard on the Judicial Council's discharge of his administrative function. Kwachi Afrenema is still here. So let's deal with this particular discharge of the 14 and the reasons that we're giving. Walk me through some of the grounds for which it was dismissed.
First of all, two issues relating to this were brought before the court, aside the substantive matter which has to do with whether or not this committee that has been established by the Judicial Council to probe the allegations or the findings, adverse the findings in Anas video concerning corruption are, how do you call it, accurate or otherwise. The court also sat on an application for injunction that was seeking to halt the proceedings of the committee entirely. But first, the High Court dealt with the injunction that was dismissed, Stephen. So let me see, that sort of gave an idea
of what's going to happen next.
What was to come. Right. Because, well, first of all, the contempt application was dismissed.
Thrown out.
It came to, secondly, the application for injunction on the committee sittings that was dismissed, and then came to the substantive matter, whether or not the committee, you know, was operating within the dictates of the remits of the Constitution, and the judge in providing her reasons for dismissing it there, even though there was a heated over an hour and a half legal argument between lawyers from the Attorney General's department. In fact, in this case, the acting Solicitor General herself and the legal representatives for the 14 judges led by John Indebugri. The court decided that, listen, this is a purely administrative function that the Judicial Council is, you know, performing an undertaking. So the courts, the High Court, cannot, you know, sort of offer a watchdog role on this function. And the one major argument that John Indebugri and the other members on the legal team of the 14 judges had put forth is that this committee was not operating within the dictates of the Constitution. And the court says, look, listen, based on the earlier ruling provided that this is a purely administrative function, there's absolutely nothing wrong with it. Beyond that, again, the court said this committee only started their work. What they are supposed to do is to probe, find out whether
there was a prima facie case against you.
In fact, whether these judges committed what we've seen in the act seen in the video or otherwise. They just started their work. Let the committee establish that before you raise these constitutional issues. As of this point, that has not been done. So certainly you have no case, and that was dismissed.
So it's interesting. But Afra, you also earlier spoke to John Indebugri. Let's hear that interview again, and we'll wrap up.
We don't agree with the decision, but so we are going to take further instructions from our client. Pardon me.
Consider
as you see, we act on instructions. The cases are not for us lawyers. The cases are for our clients. So we are now going to consult our clients, and then if they say we should appeal, we will appeal. If they say no, let's forget it, we will forget it.
You sounded so confident at the beginning of this entire matter. Did it surprise you that it came to this?
I'm still very confident. So
are you surprised by the decision of the court? You sounded very confident in your legal arguments in court and all.
You see, legal positions are normally opinions. And as I said earlier, the High Court is constituted by one person. There's a higher court, which is constituted by 3 persons. There's still yet a higher court, the highest court, constituted by 5 persons, sometimes 7. Sometimes 9.
There are some, like former Deputy Speaker of Parliament Michael Quay, who think that this whole exercise is in futility, and in fact the court's decision today to those people may mean that you may go whatever length, you still hit the rocks.
Well, I don't want to discuss individual people's opinions. I've told you that in law we deal with opinions. That is Professor Mike Okwei's opinion. John Indebugri has a different opinion. So you can't force me to accept Mike Okwei's opinion, as Mike Okwei cannot be compelled to accept my opinion. So but the point is to exhaust the legal process, and then the truth will come out. So
essentially what you are saying is that you are going all lengths to push for justice.
That is if our clients say that we should do so. We the lawyers have the capacity. We are willing and able.
So you are not disappointed? You are not disappointed?
No, why will I be disappointed? You see, when this building is solid, it was built many years ago, before many of us were born, but it is still solid. So when you have a solid foundation, you don't really shake.
That's lawyer John Indebugri there. We've been trying to raise him back on the telephone lines to get a reaction from him, especially the fact that he is indicating he will be consulting his clients to get new instructions, further instructions as to whether they will appeal against the decision or not. So that's where we bring the program to a closure. But if you've just joined us, we've been discussing 2 key issues. One, the case against John Dery, which was dismissed, the contempt case against Anas and 4 others, which was dismissed today. Justice Dery is unhappy about it and is petitioning the Judicial Council. Now, we spoke to a legal expert, lawyer Yao Opon, who says that he would have first challenged the decision before going ahead to challenge the administrative responsibilities and duties that were performed by the court, because Justice Dery says that he was not duly served and notified of a new date of hearing, and also the case, the 14 judges who filed a case in the High Court challenging the constitutional authority of the committee set up to probe them. The case has been dismissed. My name is Stephen Enti, and that's where we end the program. Enjoy the rest of our shows.